Guardianship is a relationship created by state law. It involves giving one person the duty and power to make specific decisions for another person. This is a three-part Vital Living Forum on guardianship. I'm Katie Mitzner, and joining me are retired Judge Jose Rodriguez from the 9th Judicial Circuit Court, Lori Loftus with the Regional Counsel 5th District, Shannon Miller with the Miller Elder Law Firm, and Katina Williams, a professional guardian. Our first segment will focus on the basics of guardianship. And Katina, let's go ahead and start with you. Can you explain some of the common reasons why a person may need a guardian appointed?
By virtue of physical or mental incapacity, they cannot provide their basic needs or protect their rights. So that may look like a person who starts giving loans to caregivers or their friends and there's no prior pattern of that. Or a person may have been involved in a drastic car crash and now they have a traumatic brain injury. So anything that prevents them from being able to care for their personal needs.
And from a legal standpoint, Judge, what is guardianship about?
Well, I think what Katina pointed out to you that is perhaps sub rosa or right under there, that superficially that you don't get, is that anybody at any age could require to have a guardian. Mm-hmm. And that basically is if you are not able, as Katina said, to take care of your own ability, say for example, to take medication properly, to move about. It's about civil rights, and it's about the protection of civil rights that the individual has. The right to move about, to go from place to place, to be prevented from doing that if you are going to be a danger to yourself. It is, in many cases, something that the courts require, or the courts will appoint family members to be the caregivers. But again, the concept of guardianship is as broad as, well, human interactions. Mm-hmm. You could have a guardian or a natural guardian, who's a parent, because the child has suffered a loss, say, of another parent, and there is a settlement. And that settlement belongs to the child and not to the parent. So the court basically gets involved to make sure that the guardian, the natural guardian, the parent, does not inappropriately use those funds for things other than for the child.
So let's talk a little bit about Florida law. What are some of the Florida laws that govern guardianship?
It is Chapter 744 of the Florida statutes that governs guardianship. There's also Chapter, I don't know if we're going to get into this today, but there's Chapter 393. If you have a developmentally disabled adult, then a guardian advocate can be appointed. And that's for someone like intellectual disability, Down syndrome, autism, a condition that has existed since birth and is expected to continue in the same manner without much improvement. So a guardian advocate is a sort of, would you say, like a modified guardianship, not as many rights are removed, and it is really just to allow usually a parent to be able to still continue to help their adult disabled child after the age of 18.
The wonderful thing about guardian advocates versus guardians is that with a guardian advocate, you don't have to go through the competency or the capacity analysis. So the individual is not adjudicated incapacitated.
That's correct.
Okay. And that's a big one.
Yes, it is. That's
because
very important.
it is a preservation of a big civil right.
But they still have a process. So they still, I actually had one yesterday, and it involved a gentleman who was turning 18, and his mother was being appointed as his guardian advocate. But he got an attorney appointed for his benefit. He appeared in court. He was able to talk directly to the judge about his wishes. And so, you know, the same process as far as protection of the rights of the developmentally disabled adult exists. But they don't have to be examined by a doctor and a nurse and a psychologist or whatever that examining committee would normally examine a person who's been accused, or not accused, but it's been alleged that they have a disability that requires protection.
And along those lines, can guardianship be temporary or is it permanent?
Well, that's, you know, that again, that goes back to it is as varied as human interaction, because you would hope that individuals can overcome some of their disabilities. Yes. But when you're dealing with dementia, when you're dealing with the brain and you're dealing with aging, sometimes the decision of incapacity comes at a time where there's not going to be any improvement. So the answer is yes, there are cases where you've got, and we do have a mechanism to restore rights, as well as they may never recover.
But there are situations where people have mental health issues. And for example, if you had a serious mental health diagnosis like schizophrenia or bipolar disorder, and you were not in an appropriate situation for you. You were dangerous, maybe you were homeless, maybe you were a threat to others or to yourself. And we established that guardianship at that time to help you get on your medications and to help you be safe and to help you find balance in your life. At some point, there may come a time where you're doing so well that maybe we can take some of those protections away. Maybe not restore you fully, but maybe what we might do is do a little bit at a time.
And a lot of times those clients are in their mid-20s. They are young clients. So you want them to get stable on their meds to be able to have their rights restored. But there's also something called an emergency temporary guardianship. I thought of that where if there is an emergency situation where someone's assets or their health, they're in imminent or immediate danger, it's a very high bar because you are removing someone's rights and giving them to someone else without a determination of capacity, that can be granted on a temporary 90-day basis, and then that can be extended. But hopefully you're going through the whole process of do we need a permanent guardian or can it be dismissed? But again, it has to be something there. We've seen that many times. It has to be something very serious too.
And in many cases also what we wind up having when we have somebody who's homeless is the public guardian is the one that's appointed as opposed to a professional guardian. Because again, the individuals don't have funds, and again, the public guardian is there to assist and to protect.
And I think also, one of the things that guardians have a duty to do is to exercise their authority in the least restrictive way. So when someone who is under guardianship, when we call them wards or incapacitated persons, when they can make good decisions and they're making them well, then our guardians are going to say, yeah, you can make that decision. You can make that decision on who to visit with, or you can make that decision to make that purchase. We're going to support that decision so long as it's done, really with good, I guess, like informed consent, knowing the risks and benefits of something and then making a decision with that basis.
And a part of our annual report, we must state whether or not this person has the ability to have any of their rights restored. So we review that every year.
And what types of rights are removed?
Many. It can be,
again, it depends on the nature of interaction.
It could be the right to travel, the right to get married, the right to vote, employment, education, contracts, social, determined residence,
marriage, kind of.
Yeah, that can be. Defend lawsuits,
contract,
gifts,
initiate lawsuits,
apply
for
government benefits.
Hey, between all of us, we can go ahead.
We have a whole list. We have a whole list.
We've gone down the statute.
Now, some people may not realize, but there's actually an Office of Public and Professional Guardians in Florida. What is that?
Well, first of all, let's begin where it is. It's in Tallahassee.
Okay.
Secondly, if there is an issue or a problem with a professional guardian or a public guardian, that's where you file your complaints. And that's who basically reviews whether or not the professional guardian is acting appropriately, ethically, and based upon the rules and regulations of the Department of Elder Affairs Office of Public Professional Guardians.
And they also renew our license every year.
And they monitor the continuing continuing guardianship education.
And that's relatively new. That kind of it reminds me of what we do as attorneys. We have basically an organization that polices us and makes sure that we're doing what we're supposed to do. And so the Office of Public Guardian is really intended for that reason, is to really make sure that guardians are acting appropriately and that they're maintaining their licenses properly and that they're not engaging in exploitive self-dealing or doing things that are improper. And if they are, then the filing of like a grievance against an attorney, you do the same thing with regard to a professional
It's
guardian.
about accountability. And they've got the responsibility to make sure that the guardians, the professional guardians, public guardians are accountable.
Okay. Well, I want to thank all of you for starting this discussion as we talk about the basics of the guardianship process in Florida. In our next segment, we will discuss how individuals are evaluated for guardianship and how cases move through the guardianship appointment process. Thank you for watching the Vital Living Forum. Welcome to the Vital Living Forum. This is a series of 3 forums on guardianship. In this second segment, we'll examine how the guardianship appointment process works and how it is regulated by Florida Statute Chapter 744. My guests are retired Judge Jose Rodriguez from the 9th Judicial Circuit Court, Lori Loftus with the Regional Counsel 5th District, Shannon Miller with the Miller Elder Law Firm, and Katina Williams, a professional guardian. So, Shannon, let's go ahead and start with you. Who usually notices or identifies that someone needs a guardian?
So typically in our office, we will get a call from a concerned family member, a concerned neighbor. Maybe it's someone in the person who's struggling's, church, or it can come from a variety of sources. Occasionally we'll get a call from Adult Protective Services who says, we've found someone who is, not taking care of themselves, or oftentimes it'll be that they've been giving their money away. They're exploited. And that is highly typical, unfortunately, with today, with scams and exploiters really kind of honing in on those that appear to be diminished. And so we'll get the call and we'll talk to the people about, well, have you talked to them, and have you tried to figure out a way to avoid going through guardianship? Guardianship is never something that, as those of us that work in the system, we're never saying, get a guardianship. That's your first place to go. It's the last place to go, because it does take away someone's rights. And gives them to another, even if what we're trying to do is to limit the amount of decision making that guardian will use. We always want to look at other alternatives, such as durable powers of attorney. So if someone is capable of deciding, hey, I need some help, I'd like my daughter to become my agent under a durable power of attorney and help me with my finances, that may be an alternative to guardianship that's viable. Some of the other ideas are voluntary guardianship is something that we've been using more and more, where a person still has the ability to make decisions, but they have some disability that makes it difficult for them. So
the wonderful thing about a voluntary guardian is that you don't have to adjudicate the individual incapacitated. As a matter of fact, there's a requirement that you have a certificate from a doctor that basically indicates that this individual is capacitated. So a voluntary guardian is limited pretty much to property, where, say, for example, you have someone who has a number of properties that perhaps they live off the rents, and they're not able to care for those. So the voluntary guardian is the best, least restrictive alternative.
So tell me, what happens after a guardianship application is filed? And is that correct? An application is filed?
There's a petition filed along with an application, an oath. It's many documents. Usually once that's filed, the case is initiated, and an order is entered appointing an examining committee and also appointing an attorney. And I work for the Office of Criminal Conflict and Civil Regional Counsel 5th District. It's a mouthful. And so we represent indigent clients. We're court appointed, so it's either me or an attorney on the registry. And so once I get appointed, I go out to see the client. I have a notice of petition that I have to read the client, which it's a very clear petition. It says, or a notice, it says, you are hereby notified that petitions have been filed to determine you to be incapacitated and to seek an appointment of a guardian. Tells you the day of the court, who the judge is, where to go, your rights. You have the right to an attorney. You have the right to call witnesses, to be present, to participate. And it does clearly state that if a guardian is appointed, you may lose your right to control your property, your person. Someone else could be regulating your social activity. So it's a very clear notice. That's usually how the process goes. So all the paperwork's filed, the case is started, attorney's appointed, the examining committee will go out. There are 3 members, and it's just at that stage are all just examining and making, forming opinions about that person's capacity.
So there's a committee, there's 3 of us. So one has to be a doctor. So it can be a psychiatrist or a medical doctor. The second one can just have a general field, registered nurse, nurse practitioner, licensed social worker, something in that general field. And then my position is what we call a lay member. Just through training, experience, background, you have some experience in determining incapacity. And then we go out, we must meet with the alleged incapacitated person physically, face to face, and we must speak with them in their first language. So what we're trying to determine is the basics. Can they determine what they need? So can they determine their basic needs, and also can they protect their rights? And then we do a report to the judge, and we have a couple of recommendations that we can do. I think we'll ask that a little bit later, but we'll put in our recommendations. We have 15 days to get that done and sent back to the judge.
And what actions can a judge take?
Well, basically, it depends on what the recommendations are. Basically, the statutes say that if you've got a majority of the committee indicating that the individual is incapacitated, then you can go ahead and proceed to the petition, finding the individual incapacitated, and then looking and seeing what rights you allow to continue to be exercised by the individual, as well as what rights are going to be passed on to the guardian. You also have, the consideration that if most of the time all three recommendations agree.
Close.
Right? But the other side is when you have a majority that disagree with the individual filing the petition and find that the individual has capacity, then what the court has to do is dismiss
So
the
if two
petition.
of the three of us
But it's
decide.
always it's a majority at this point. 2, incapacity, proceed to appoint the guardian. 2, capacity, case dismissed.
Case dismissed. So Katina, what are the requirements to be a guardian? You are a professional guardian,
Yes.
which is different than a family guardian or public guardian?
Yes.
Okay.
Family guardians, they're appointed before. So they go into court, they get appointed, and then they have to get their education and take the classes after. Professional guardians, we have to show that we are capable of walking into any situation. So the professional part simply means we did not know them prior to being appointed. So in the state of Florida, you have to be at least 18 years of age. You must take the initial professional guardianship course, which is 40 hours. After that, you must pass the Florida professional guardian examination. And once you have that, you must be able to obtain and then maintain a $50,000 bond, blanket bond, covering you with your wards. And you have to pass a level 2 background screening. There's a couple of misdemeanors that fall in there, but for the most part, you cannot have a felony conviction.
Now, in terms of, let's go back to the examining committee. What recommendations can that examining committee make? Are there different, we've talked about different levels of guardianship. I don't know if you refer to it as levels, but what can they recommend and how does that get decided?
So
We're all like jumping. No, it could be no guardian needed. It could be a limited guardian needed. It could be a plenary guardian needed.
And then and even with a plenary or a limited guardian, what they can wind up doing is they can wind up making recommendations to the court of you keep this right, you delegate this right, you delegate this right, you keep this other right. And again, you wind up with if anybody knows what the word smorgasbord is, you wind up with a litany of rights that you can, as you may have heard us in an earlier program, go into, that can be on an individual basis restricted or...
Because it used to be that you had all your rights taken away. It was like all or nothing. And we found that to be really impractical because people may be very good at managing their finances, but they may not be able to manage issues related to residence. They may decide, I want to live at home even though I cannot seem to get myself fed or bathed or, so it can really be as individual as people are. So we try to create legislation, and now the law is such that the court can determine that, hey, this person can retain their right to vote. They are very, very educated when it comes to reviewing the news and keeping up with politics, and they certainly can do that, but they're giving their money away. And so we need to make sure that we lock down their ability to manage assets.
Well, thank you very much for explaining the guardianship appointment process and how it works here in Florida. In our next segment, we will be discussing guardianship monitoring and oversight. Stay with us. Welcome to the Vital Living Forum on guardianship. In this third and final segment, we discuss the monitoring and oversight requirements established by Florida Statute Chapter 744. My guests are retired Judge Jose Rodriguez from the 9th Judicial Circuit Court, Lori Loftus with the Regional Counsel 5th District, Shannon Miller with the Miller Elder Law Firm, and Katina Williams, a professional guardian. So we hear a lot of words when we talk about guardianship, and one of those words is ward. So can we clarify exactly what that means?
A ward is a person who has been declared incapacitated and has a guardian appointed, I guess is the simplest way to say it.
Yes.
That's right, and it can also be a minor. So
Right.
for example, if we
Yeah,
have a
a minor.
guardianship of a minor, then that might be a minor ward.
That's true.
Or an incapacitated ward. But the word, I think, doesn't have the best connotations. Unfortunately, that's what our statute says right now, and so we use the legal terms that are reflected in the statute. I think there's been some movement towards changing that word because it doesn't feel great. I think all of us
Right.
don't really feel comfortable with
It doesn't describe the individual.
Right.
I like to use the word, and I try to use it as often as I can, and I teach my students that a better word, at least for me, is a protected person. In fact, that's exactly what we are all engaged in doing. Every part of the system is engaged in protecting this individual, protecting from the encroachment against their civil rights, giving them back when it's necessary, taking them away when they might be, better off without those rights or the rights being delegated. The most famous ward out there is Robin in the Batman series, because he embodies somebody who is capable, but again, because he is underage, somebody has to take care of him. That's why he has Batman, the adult.
Well, and we'll remember that.
Yes.
We will remember that example. Now we know.
So ward can mean many things.
Exactly, a protected person.
Now, let me ask you this, and Katina, let me direct this to you. So, how are guardians monitored to ensure that they're acting in the best interest of their ward?
Or guardianships are monitored on their statute 744. So there are some statutes that require the guardian to seek court approval before we can do anything. So that's one way. And then our circuit, the 9th Circuit, we have a court monitor. And so if there's something going on, any allegations with the guardian or the ward, the judge will appoint the court monitor to follow that case. And then lastly, we have the Office of Public and Professional Guardianship, where any interested party in that case can go online and they can file their complaint with the office that actually monitors and licenses public professional guardians.
And I would also just add that, Adult Protective Services is an entity that exists in the state of Florida. If there's ever, anybody who's listening out there, if they feel that someone is being exploited or is being maltreated or abused in any way, then we'd encourage them to call the Elder Abuse Hotline, which is very, very important for people to know. Anybody can call. You can make a report anonymously, and an investigation will take place within 24 hours after that call is made.
So, as we talk about this, who can file a complaint? A ward of any kind can file the complaint, and where is that actually filed? And what's that process?
The statutes that govern the court monitor are two. One of them is for a regular court monitor, the other one is for an emergency court monitor, which is the same thing but just more souped up in terms of time. Eventually, what the court monitor does is that they provide a report to the court. Any individual or the court on its own motion can go ahead and either appoint or call upon the court monitor to investigate, And again, as part of that investigation, a report is made to the court and disseminated to all of the parties. If there is probable cause for there to have been action or for the action to be taken on a criminal basis because someone is stealing money, then the court can refer that to the state attorney's office for additional action. The court also can take other steps, such as, again, at the instigation of the court monitor, can freeze accounts. I know that while I was on the bench, there was one year where, because of the work of our court monitor here in the Ninth Circuit, about $500,000 or more were returned to the wards, to the protected persons and their assets, because again of the investigations that were done and the discussions with the sheriff's office that took place. So it's not every county, not every circuit has one the way that we do. Our court monitor is paid by government funds, but it is a tremendous asset in ferreting out. When the one case I can tell you is that she was able to get a group of volunteers to do forensic accounting on one particular guardian, and we found, or she and her group found, that this guardian was charging for the equivalent of 41 hours of guardian work for one particular day. 24 hours, right? Well, no, she was charging 41. And it wasn't just one day isolated, because you had 24, 26, all over. And if we didn't have that court monitor, we wouldn't have been able to know the extent to which this guardian was basically, double charging, double billing.
So let me ask you this. What actions can the court take against the guardian or the attorney if they see this, or this is proven?
I mean, and Judge Rodriguez can talk about some of the things that they do, but I mean, there have been situations where we will surcharge. We will require the guardian to pay money back, sometimes even attorney's fees. I know there was a case recently in Alachua County, which is where I practice, where the court ordered the reimbursement of $110,000 to the ward's estate, and then banned that guardian from practicing in our circuit.
You can remove the guardian if it's an isolated case, or if you've got basically a family guardian. But in a case where you've got a professional, you can just
And they can be grieved through the OPPG process. The court can actually refer the case for a grievance to go through that process. And I mean, there are other things. I mean, the referrals to the state attorney's office if in fact it was theft. But I really think that the court in general is going to try and do the right thing, but obviously needs information. And that's why I think a court monitor, and I'll tell you that in Alachua County, we don't have a court monitor. And so just hearing this makes me think that maybe this is something that statutorily should be required across the state to help.
It's really great.
The critical thing when you have a court monitor from a judicial standpoint is that you cannot in any way, shape, or form act in a way that's going to make the court appear to be unfair or biased, which is why you have the court monitor do the report and then you pass it along to everyone else. The statute requires a hearing where everything is put out there to figure out whether what's in the report. You know, it's similar to an information or an indictment, where there are allegations of doing wrong. So the hearing is there to provide due process for everyone to be heard as to whether or not what has been found by the court monitor is factual and whether or not the court needs to take additional action.
And it's not always negative,
No,
the job of the
that's
court
true.
monitor. Because as a professional guardian, I've requested a court monitor. Especially when you think that there's a lot of financial exploitation. Once you get the court monitor involved, they can go straight to the financial institutions, freeze. They can do a lot of stuff a lot faster than a guardian can. So it's not always negative. Sometimes I've asked to have them on my cases.
It makes her job easier.
Yes,
Right,
it
right.
really does.
Well, in just a little bit of time we have left, I'd like to go around and have you share your final thoughts briefly on guardianship. What do you want to leave people with, leave the viewers with?
Guardianship should be your last resort. So I would strongly recommend getting an estate planning, go and see an attorney, designate a healthcare surrogate. That's probably the easiest and fastest one. You may or may not need a power of attorney, but have somebody in mind. Have a talk with your family. Let them know what are your end of life decisions, so you won't have a stranger like myself coming in as a professional making that decision for you. But you have to talk about those things that are hard and difficult. But I definitely recommend going to and doing an estate planning.
Okay. Judge?
Katina, I think you are right on. If you don't plan, you wind up being surprised. And then again, not being, well, enjoying your family in your last days as you should. The older I get, the more profound it becomes that young people need to treat those of us who are aging with the dignity and respect. And that comes, I think, and it's born out of a understanding that we're all in this together. More than anything, the one thing that we're going to share is that we're all going to age. We all age as we grow up differently. Some of us mature quicker than others. Some of us age quicker than others. And it's understanding that sooner or later you are going to be walking in those same shoes.
Right.
That I think brings me to hope that we can teach the young to be good guardians.
And I think the other part of this equation is if you see something, say something.
Right.
So if you see those people that are being exploited, or you have a concern that they are, you really need to get the government involved, whether that's a call to the elder abuse hotline, whether it's contacting an attorney and saying, what do I do? I've found this person who's definitely in crisis and needs help. So, you know, we really need to take care of each other. And I think that all plays together with the guardianship process.
Lori, final thoughts?
And this is such a serious topic to remove someone's rights. If you do find yourself or your loved one is in a guardianship situation, I believe all of us work very hard to follow the law and get it right. So make sure that your loved one is treated with dignity and taken care of.
Katina, Judge Rodriguez, Shannon, and Lori, thank you so much for joining us, and thank you for watching this Vital Living Forum on the Florida Guardianship Process. We also have a 3-part companion series on elder law, which includes a discussion on the steps families can take to reduce the need for state guardianship of an individual. You can find out more at orangetvfl.net. Thank you for joining us.